and welcome to the live broadcast. I'm Patricia Roberts. It is 1:30 p.m. in the UK. I'm joined by Richard Nelson, who's partner at King & Spalding, where it is 8:30 p.m. in Singapore. And I'm also joined by Christopher Goncalves in Washington, DC, from BRG, where it is 8:30 in the morning. I'm the moderator for the session. And I expect that it'll be somewhere between 40 minutes, perhaps up to 1 hour long. And you can all send in questions if you would like to us, which we will try to answer either live or we'll endeavour to sort of answer the questions after the broadcast. First of all, we're really pleased that you're joining us. Wherever you are, and we believe we have a few hundred people or more joining us here, we really hope that you and your families are safe and well. And our virtual panel today, and I'm really pleased to invite, Richard, partner at King & Spalding in Singapore, Chris Goncalves, who is the chair and managing director of the LNG practice at BRG, are going to take on quite a task for ourselves here in terms of the topic. We're calling it Taking Cover from COVID-19 under LNG contracts. And the whole purpose of this is to look at how LNG contracts, long-term sales and purchase agreements, can be used in some way to help moderate, ameliorate the effects of the virus, the downturn in demand, and the effects on LNG participants. We really are in unprecedented times. As at today, we have over 2 million cases confirmed of COVID-19 in 210 countries around the world. And 187 of those countries have invoked some type of lockdown or restriction of movement of people in order to try to contain the spread of the virus. So businesses, factories, service industries are at various stages of shutting down. Oil demand is expected to fall by around 30 million barrels a day in April. Oil prices this morning in London trading at around $28 a barrel for Brent. And promises of government stimuli to aid recoveries when the pandemic is under some form of control could put governments in debt for the next 50 years. Everyone's predicting a recession, perhaps larger than the Great Depression. And specifically in LNG, this couldn't have come at a worse time. We were already seeing falling prices in January 2020 because we knew that we were not having a very cold winter. We had 35 million tonnes of additional supply coming to market this year. And before the virus really took hold, we were expecting European LNG prices to be around $2 in the summer anyway. But the reason for this broadcast is because we hear that some companies are really struggling to absorb their LNG volumes and they're looking for relief. And you may have read that up to about 9 companies, I think, have come into the press in the last 1 or 2 weeks looking to claim force majeure relief under their contracts. So notices are being sent to suppliers. There are expectations of some LNG shut-ins later in the year. So our focus today is to what extent can the clauses in the SPAs provide some relief or cover? And we're going to look at specifically volume flexibility in clauses, force majeure, and the material adverse effect and the hardship clause. And we'll assess how these clauses can provide some relief. And there's 2 aspects here. One is an expert legal advisor in the form of Richard, and the other is in the expert advisory and analytics from Chris. So we're going to cover the practical, the legal, the analytic, and the expert issues around those topics. So let me start, first of all, with Richard. And Richard, let's start with volume flexibility. Can you set the scene for us as to how effective volume flex provisions can be at helping buyers manage sudden changes in their LNG demand?
Yeah, thank you, Pat, and very warm greetings, everybody, from Singapore. I hope you can all hear me okay. Okay, so starting with volume flex, and I guess here we're really talking about contractual mechanisms such as DQT, downward quantity tolerance, UQT, upward quantity tolerance. So let's just stick to those for the time being. First point to note is that in most cases, certainly most long-term SPAs now, it's quite common to see provisions allowing for some sort of volume flex. So the likes of DQT and UQT are pretty commonplace in most long-term SPAs now, certainly compared to SPAs of yesterday, so 10, 15 years plus ago. I think to your point, to your question, Pat, they are effective, but there are clearly limitations in terms of how effective they are in mitigating the risks that many buyers are facing today. So if we look at the knock-on effect of COVID plus the oil price sort of wars or the oil price crisis, there are clearly soft market conditions, softer than many of us have seen for a very long time. And so yeah, it's not unreasonable to expect buyers to perhaps look at exercising some of these rights and are essentially asking to take less or committing to take less volume than they would ordinarily take. And they may do that for a number of reasons. One of them may be to reduce their underlying take-or-pay commitments. For example, if they don't feel that they're in a position to sell those volumes further downstream and so on. I say there are limitations though, because exercising a DQT right in and of itself will only go so far to helping to manage the situation. In other words, the right itself in the contract is normally limited in terms of volume. So in other words, you can only exercise the right up to a certain amount, i.e. one cargo perhaps per year, one or two cargoes out of the ACQ, the annual contract quantity. It may also be limited in terms of timing. So a number of contracts will require that the buyer comes forward to exercise the DQT right when the annual program is being set. So in other words, before you get into the relevant year, 3-4 months before that, the buyer may come forward and say, look, we anticipate soft demand in these months, so we're going to exercise our DQT rights in those months. It's possible, but it's unusual to be able to exercise DQT in real time. Some contracts allow a buyer to come forward during the setting of the 90-day schedule, or even closer to the delivery date, to exercise the right to essentially say we want to drop a cargo from the schedule. But as I say, that's pretty that's much less common than during the ADP process. And the final limitation that I would just caution people about, or note, is that it's not unusual for contracts to say that in buyers exercising a DQT right, they will do that fairly and equitably and treat their suppliers, all their long-term suppliers, on a fair basis. Now, you can imagine how difficult it is in practice to say what does that fair and equitable basis really mean. And it's very case dependent. It will depend on the specifics of one SPA versus other portfolio SPAs that the relevant buyer has in place. But it does mean that exercising the right isn't as straightforward as perhaps it sounds initially. In other words, there are other considerations to bear in mind before stepping forward to exercising the right, and then once you've exercised it. And that may mean looking at your terms, the terms of other long-term contracts, and deciding how to allocate your quantities, your downward quantity tolerance, across a number of different contracts, as opposed to only under one of your contracts. So there are nuances. And last but not least, there's a sort of quid pro quo behind DQT, which sometimes gets overlooked, but that's the make goods concept. So here what we're talking about is the buyer having come forward to say, I'm exercising my DQT right and I'm taking one less cargo perhaps than I had in my original schedule. And the seller may say, okay, we can accommodate that one cargo DQT. However, in the next year, we would like you, buyer, to make good that cargo. In other words, the seller then has the right in a future year to come back to your table and ask the buyer to accommodate and make good cargo.
Yes.
And just to be clear, make good is different from make up, just in case there's any confusion about the terms we're using here. Mm-hmm. So again, the buyer has to decide in a future year whether it will be in a position to take that make good quantity or not. And sometimes that's subject to reasonable endeavours. Sometimes it's an absolute obligation to take and make good cargo and so on. So yeah, as I say, I think they are helpful provisions. They're in most contracts. It's just a question of understanding the nuances and how to go about exercising them when you actually get to that point.
I guess it's fair to say that when these clauses were conceived originally, they weren't conceived around sort of things like the situation we have today of a pandemic and a sort of, real massive shutdown in lots of people's businesses. They were managing operational sort of fluctuations. But I'd like to bring Chris in here and say, Chris, from your point of view, how effective do you think volume flex is going to be in helping buyers manage their volume demands?
Yes, so I was going to make, and I will pick up on the point you just made, Pat. And hi, everyone. Thank you for joining us today. And I echo what Pat said. I hope you're keeping well and safe. And I look forward to a near future where we can all meet again at one of the CWC conferences. Pat, picking up on your point and Richard's very helpful summary, I think the main point I wanted to make is that these kinds of provisions are principally intended for operational flexibility, seasonal flexibility. They're negotiated in contracts, commercially intended in contracts to be used for variations in supply and demand and downstream markets, for operational considerations, seasonal considerations. As such, they're typically limited to, depends on the contract and the region and the nature of the contract and so forth, but more marginal kind of amounts of flexibility, 10, 15% of an annual contract quantity or something of that nature. And also, as Richard said, subject to make good considerations and all of that. So that's really not intended for the kind of circumstance we're dealing with right now. And it's certainly not adequate in some cases to deal with the kind of circumstance we're dealing with right now. The last kind of commercial point I wanted to make is that those provisions, although intended mainly for operational kinds of reasons, are also open commercially to any kind of usage, including commercial usage or optimization. So flexibility, as everyone says, a bit of cliche in the industry, has value. And to the extent, a buyer has flexibility, it may have negotiated for some of that flexibility, not just to meet its operational needs, but also to meet its commercial objectives. To be able to buy under UQT an additional spot cargo when it's attractive, even if you don't need it, perhaps you can resell it, and vice versa under DQT to be able to reduce consumption of long-term contract volumes when spot cargoes are cheaper, if you need the LNG and the contract price is high. So it's available for that kind of commercial optimization or cost saving kind of purpose without restriction. I mean, it's sort of, that is a part of the goal of the flexibility for some parties is not just the operational, but also the commercial. In any event, it's negotiated and it's limited in nature and not usually intended for this kind of circumstance.
The other question I wanted to put to you, Chris, is about US LNG, which of course has got a volume flexibility inherent in it because you can cancel cargoes with notice. And if you look at the price combinations today of Henry Hub and JKM and Henry Hub and TTF, those price combinations are falling below the marginal cost for some off-takers. do you think that we will start to see quite a lot of volume flex in terms of turning down liftings out of the US as a result of this?
It's very hard to say. It's been remarkable, the situation of cargoes being lifted and sold certainly below full cost, and at, in some cases, below variable cost has been interesting to watch. I think it depends on the individual incentives of the parties holding the lifting rights or the capacity rights at the LNG terminals. If they can make a margin or break even, of course, makes sense to trade those cargoes. Where they can't find a buyer, and or they can't, or they would lose material amount of money, that will obviously not make sense anymore. So if we come to those, and you have seen some cargo cancellation, so that may be something that happens for a period of time, especially in the current environment.
Okay, well let's move on to probably the next option, which is perhaps where people are saying this is where we want some advice here, which is force majeure. So we hear that there are companies that are struggling to absorb their volumes, they're looking for relief, and out in the press there's been various notices put out that Chinese counterparties, Spanish, Italian counterparties are looking to invoke force majeure so that they are able to get some relief from receiving cargoes. And I think my question to you, Richard, is it as simple as it sounds? Can you invoke COVID-19 as a reason for why you cannot receive cargoes?
The answer is yes, potentially, as most lawyers would say.
Yes,
things are never as simple as they seem. Look, I mean, it clearly, given everything that's unfolded, folks are looking at FM very carefully. It's no longer just a sort of boilerplate clause at the back of an SPA. Suddenly, it's absolutely front and center for good reason. Just before we get into the specifics of COVID, though, I mean, a few points to note on FM. Firstly, that if you don't have an FM provision in your contract, then you will not be entitled to FM relief. There is no underlying concept under English law and US law of force majeure relief. So whatever you have or don't have in your contract is as good as it's going to be. Your position is only as strong as the force majeure clause in your contract, number one. Number two, what we're really talking about here is a non-fault-based concept. So FM sort of came about to try and cater for acts of God type scenarios. So in other words, something completely external or extraneous to the contract that the parties could not have foreseen, did not cause, and had no control over. And that's the fundamental test in pretty much every contract for FM. There's often a bit of confusion about the list of FM events that we often see in a contract and the list of exclusions equally that we often see. But fundamentally, and those lists, by the way, are only for illustrative purposes only. They're only examples of what may constitute FM or may not constitute FM. It doesn't necessarily mean that if you fall within one of those specific cases, you will automatically qualify for FM relief. The test, the key test, is whether the event that you claim prevented you from performing your obligations was foreseeable or not. Number one, and whether it prevented you from performing. On the prevention point, it's also just important to note that just because things get harder because circumstances are more difficult or even more expensive, that doesn't necessarily mean that you're able to claim FM relief. So if we look at COVID, the COVID sort of pandemic crisis, whatever you want to call it, I think in most cases it's fair to say that it was unforeseen. I don't think many people, at least in the early stages, saw this coming down the tracks and the devastating effect that it would have on the industry. I think the key consideration with COVID, and I think this goes perhaps to some of the claims that are in the market today, is what exactly the party is claiming FM for. So in other words, is the party saying, I simply cannot perform, I cannot take delivery of X number of cargoes, I cannot, I cannot even access my regas terminal, I cannot provide staff at the relevant ports. And if so, does that prevent that party from performing its obligations? It may do, but equally it may not. And I think this is where some of the nuances lie, because it may be possible, for example, for the party to bring in an alternative workforce. It may be possible for the party to move the cargo to a different receiving terminal, which is unaffected or less severely affected by COVID. So, as I say, it's not as simple as saying, this has happened, life is much harder, I can't necessarily take delivery at this particular terminal, or I can't perform certain of my obligations. The test is whether it entirely prevents you from doing what you have said you would do under the contract. And that often is a slightly different test. So I think if we look at some of the mood music in terms of the claims that have been filed and the responses and the rejections to those notices, I think that's where the sort of balance, where the balancing act is to be found. One party saying, I can't do this, the other party saying, well, actually you can, if you did it a slightly different way, or if you took different measures to perform your obligations. Mm-hmm. So, I think, as I say, I think it is a possible trigger. It is possible to invoke COVID to claim FM, but it doesn't get you necessarily across the line in terms of actually being able to say, look, we're not performing our obligations at all.
Thank you. That's very helpful. Chris, can I ask you just to come in on this point here and say, what typically would you think the analytical and evidentiary issues would be to support a claim for FM for COVID-related prevention? Sure.
That's a great question, also a huge question, just because there's such, as Richard was indicating, there's such a wide array of types of force majeure claims, but I'll try to focus in on COVID type issues. And first, maybe just by way of a clarification to make sure everyone understands, I am not a lawyer. I'm an economist and an energy expert. And so the role that I play is working with or for law firms like King & Spalding when they make force majeure claims on behalf of clients or defend claims on behalf of other clients. And the kinds of issues I get involved in are analyzing, for example, Richard indicated some of them, issues of foreseeability, issues of mitigation, issues of causation. And I think I'd like to kind of focus in on the last point because I think it picks up on some of the themes Richard was weaving in terms of the need to demonstrate a claim. I mean, he said, just because there's a connection between something happening in the outside world or a pandemic or other kind of event of force majeure and a list that's given in a contract under types of conditions qualifying for force majeure doesn't automatically mean that force majeure is invoked. And sometimes you have to prove that in fact it is that event that caused the inability to perform, the inability to receive, etc. And what often comes up is counter arguments from an opposing party along the lines of, well, there may have been some impact, or undeniably there's some impact, but there's also a more powerful driver out there that is motivating this decision. You could have mitigated, for example, and you weren't really just trying to not take a cargo, for example, because of COVID or its effect on demand, but rather because of low oil prices or because of some change economically. And I would just say generally, so there's issues of, what is COVID? What does it do in terms of performance? as Richard's example indicated, there can be operational considerations. It could take a ship out of service. It could take a terminal out of service. It could interrupt a supply chain. There are issues of demand. It could downstream, excuse me, downstream in an end market, harm demand and eliminate the need for a cargo or series of cargoes. There's issues of price, which are obviously related to demand, and how those things are affected. But there's also other factors going on in the market with respect to price that have to do with the OPEC agreements or the competition, the effect on oil prices, the effect on LNG prices, and then just the overall LNG environment, which was already difficult and complex, I guess you could say, generally speaking, before COVID, and has only gotten more so since COVID. So as you can imagine, with all those different issues afoot, it's quite important and sometimes difficult to sort through and create sort of a direct line or analyze whether indeed there is a direct line between the COVID, the effect on whatever it might be, operational or demand, and the force majeure claimed. And of course, there can be other factors involved that need to be analyzed and sorted through as well to make sure that it's not a claim about force majeure, but really the issue is something else.
Thank you. I've got some questions which have already been coming in now from people listening in. And one question, Richard, perhaps to you, it's saying, if the FM claimant can't sell the regasified LNG to its customers because demand's fallen off a cliff and there's nowhere for the gas to go, should FM be valid? And would it mean that DES contracts are going to be a lot easier to claim force majeure on because they're directed at delivery to a specific country rather than FOB contracts?
Yeah, it's a good question. And I think, again, trying to be as on point as I can, I think the answer is probably no. In other words, just because a party may have difficulties on selling volumes downstream for whatever reason, doesn't necessarily preclude that party from taking delivery of an LNG cargo at the designated terminal, if you see my point. The test, as I said, as I was saying earlier, is whether whether an event has occurred which prevents the buyer under a long-term SPA from taking delivery of the relevant quantity, the relevant cargo. So it may be more difficult, and I'm sure in some cases it is more difficult for the buyer, having taken that cargo, to then on-sell it as our LNG, regasified LNG downstream. But that's a different question. The question to consider here is whether or not they could take delivery of the cargo in the first place. And most contracts that we see in the market today will specifically exclude from FM so market conditions, if you like. So, you know, unfavorable pricing or uneconomic sales, uneconomic resale conditions, for example. So most contracts will try and exclude those kind of more general prevailing market conditions from being FM at all, and will specifically say that. So I'm afraid from a buyer standpoint, this is one of the really difficult juggling acts, is in terms of saying whether or not I can accommodate the cargo that's required to be delivered to me in the first place. If yes, what do I then do with that cargo? But as I say, that's a separate question for these purposes. And I don't think would entitle that party to step up and say, look, I'm claiming FM, if it was actually in a position to take that cargo in the first place. I think on DES versus FOB, I'm not sure that in practice there'd be much between the two. I mean, obviously, yes, the considerations would be different as to where the delivery was required to take place, delivery of the cargo or loading or unloading of the cargo. But I mean, going back to the point Chris made, this is very fact specific. You know, it all hinges on what specifically and what exactly happened to prevent a party taking delivery of a cargo, whether that was at the loading port or the unloading port. So again, it comes back to that analysis here, excuse me. And so you'd run the same analysis under either an FOB or DES contract. They'd be sort of indistinguishable on that level.
Okay. Another question, perhaps Chris, you can give us your views first and then on to Richard. Do you know if there are any sellers that have actually currently accepted buyers' FM claims due to COVID-19 at the moment? That's come in from our audience.
That's a good question. I'm just sort of rifling through the news of the last several weeks to see if I can remember anything where there was actually sort of an agreement or settlement. I guess I would say I'm not aware of any formal acceptances. They're probably confidential, but
Yes.
haven't heard of anything like that. But I guess I'd be surprised if there weren't cases where they've just agreed on the force majeure interpretation and the period. Another thing we haven't talked about, maybe we can come on to at some point, is the duration as well. That's sometimes a tough analytic issue, is sort of where did it start and when does it stop, and how do you determine that? Those would be the things, obviously, for a buyer and a seller to agree upon when they accept force majeure.
And a question that we've just had come in, Richard, is saying, if there's a sort of a government statutory requirement to lock down, is that then a much more simpler case of a test for FM that a buyer can't perform because there's a statutory requirement from their government to lock down, shut down, socially distance stuff?
Yeah, I mean, it goes back. I mean, the answer again is yes, in theory, but it depends on what your contract says specifically. So the fact that you are ordered, and so we're here more in the realms of political governmental type FM, not natural FM events, natural sort of disasters and the like. So if a government order required you to shut down your facility, say, and thereby you could not deliver or take delivery of a cargo, then yes, I mean, clearly you could say that providing you didn't know that was coming, and that's important, but providing you weren't given advance notice of the shutdown, which sometimes, you know, if we're talking about a government-owned company, for example, may be quite tricky because, you know, there's always an argument that if you're part of a government family of companies, you may know more about what's coming down the tracks than external parties. So often you sort of get into arguments about what a government party should have known in advance of the relevant shutdown. But assuming for these purposes that it didn't know about the shutdown order in advance, and it couldn't have prevented that or controlled it, then yes, in principle, you could argue that that amounted to an FM event. The problem here lies often in the fact that a lot of contracts increasingly try and, again, exclude those types of events from FM at all. So they specifically say that a government order does not, a government declaration, a decree, for example, does not in and of itself constitute FM under that specific contract. It's entirely possible and entirely permissible to say that specifically in your contract, particularly, as I say, if you're dealing with a state-owned or government-owned company and you may have concerns about, you know, how much they know about what's going on a political level. So my advice here would be to think very carefully about whether you'd be comfortable with your counterpart claiming FM for those types of political or governmental events. And if you are concerned, then consider excluding them.
Okay. We're getting so many questions here. Thank you to everyone who's listening in for sending in your questions. I'm having to group some of them now into themes. Here's an interesting one. Perhaps, Chris, you could have a go at this one. It's basically saying that if various ports and terminals have activated the FM clause, then how much risk is there for charterers who can't go to these ports suddenly? Because we're talking always about the buyers and the risk and the sellers, but how about the sort of the charterers sometimes?
You're saying the risk to the ship chartering company?
Let's take that on, because I think that's a new angle. Yes.
Okay. obviously there's risk, because if you are chartered to deliver on a certain route and one or both parts of that route are affected or taken out of service, that's obviously problematic. If one or both of the parties, the buyer, the seller, and particularly the seller chartering the ship, assuming it is the seller. Let me back up. Assuming the party that is chartering the ship claims force majeure for that reason, then of course, there's an issue where you can't collect for a period of time. But there's the broader, that would be the specific force majeure related risk or cost. But there's the broader issue of the overall effect in the market on demand and ship traffic. We've had some periods recently, as you know, with quite a bit of floating storage and essentially storage volumes filling up, physical onshore storage volumes filling up, ships being used for storage, partly for pricing and sort of temporal arbitrage, but also sometimes because cargoes need to be loaded but yet can't yet be delivered. That's becoming an issue in some cases. So where those things are happening as a sort of broader or general consequence of COVID, that obviously just affects the economics of shipping and drives charter rates down and puts the business in a position of temporary risk.
Yeah. Richard, did you want to add anything on here on that point?
I was just going to go back a second, Pat, if I may, because the point we were discussing about government orders, I think it is obviously relevant, and it has underpinned some of the claims that we're seeing. But there's another nuance about, from a legal standpoint, about FM, which is that if you claim FM for several different reasons, so let's say, on the one hand, you're told you're subject to a government decree which prevents you from opening a facility, but your contract says specifically government orders do not constitute FM. And at the same time, you're saying there's a strike in the workforce, so that's also preventing me from opening my terminal or actually, being able to take delivery of the cargo. So there are two simultaneous events, one of which constitutes FM under my contract, one of which doesn't constitute FM under my contract. The general position at law is that would preclude you from claiming FM entirely. So you've got to be careful here, and it goes back to the point I made at the beginning about being very, very clear what it is you're relying on to claim FM for. And if you're not careful, and if you try and claim on several different grounds, and this has happened several times in the industry, if you try and claim on several different grounds, you can inadvertently trip yourself up by claiming on one ground, which under your contract isn't FM at all, and thereby rules out the validity of your entire FM claim, whether or not some of it was founded on, on specific parts, provisions in your contract. So again, something just to watch out for. The party may say it's actually a government order that's preventing me from complying, and try to almost hide behind that excuse or that event or that reason. But actually the real reason is something entirely unrelated. And as I say, that can actually give rise to some really difficult issues. So
that is such a helpful point here, because you are saying be very, very careful about how you go about making the claim. It's a marvelous sort of segue as well to say how you need lawyers and expert advisors to help you with the claims, isn't it?
Well, if you want to go there, Pat, don't stop you.
Won't stop.
I think it is. I mean, clearly there's so much talk about FM at the moment in the market, and as I say, it's understandable. But we shouldn't be under any illusions. This is quite a significant step to take under a contract. So you do have to make sure that you are clear. You know what exactly you're relying on, and you've checked in advance of serving your notice that in itself does constitute FM under your contract. Otherwise, the likelihood is you'll be pulled into a dispute. You'll have experts like Chris poring over the analysis, the technical details as to what happened or what didn't happen. And if your claim is invalid, if your claim is held to be invalid, then actually you were not entitled to FM at all in the first place. So therefore, you should have carried on performing, but you may not have done. And you then have to look back at that whole period of time and ask what recourse the other party should have for your failure to perform. So you can get into all sorts of problems.
It is. I mean, I've got lots of questions pouring in. I'd like to group them in a sense because a lot of them are linked around, the buyer unable to perform, wants to claim FM, wants the protection. But just on a very practical level, Richard, to ask you first, let me say I am a company that I want to claim FM and I go about it to my supplier and my supplier rejects it. What actually practically happens? Do you reach an impasse, or how do you manage a circumstance where the buyer is saying, I claim force majeure relief, and it's rejected? Or it goes into suspense?
Well, I mean, Pat, well, I mean, in practical terms, the answer is easily resolved. So you've got a disagreement on your hands, haven't you? You've got one party saying, I couldn't perform for this reason. The other party saying essentially, yes, you could. Or the reasons you've given are not actually, they don't amount to FM.
Yes.
So either you resolve that disagreement commercially, you may look at some rescheduling, you may look at moving some cargoes around in your ADP or your 90-day schedule or whatever steps you feel you can take, or you escalate to a formal dispute. So you actually, move that to the next level under your contract. You would then refer to either an expert, potentially to arbitration, or a court resolution process, which may obviously take some time. And that was the point I was making earlier, and why you have to be careful doing this, because if you claim FM and it is disputed, and ultimately the outcome of that dispute is found not to have been a valid FM claim, then actually the position at law is that you should have continued to perform your obligations. You were not excused, you were not relieved legitimately from performing.
Yeah,
so you're in a position then.
Yes.
Exactly. So that's my point. Even if you make the claim, don't necessarily assume that gets you off the hook, because you're only actually off the hook if the other party agrees to accept it, or if it goes to dispute, a court or an arbitration panel finds that you were legitimate in making that claim.
Mm-hmm. And Chris, here's a question from one of our audience, which is saying, in your professional opinion, do you think that we are going to have a plethora of FM claims?
Well, I think there already are. Hard to define what constitutes a plethora, but there will be a lot. There already are a lot, I think. In terms of claims between parties, going the next step to what Richard was just describing, which is going into some more formalized dispute where they disagree, as in expert determination or litigation or arbitration. That's hard to say. I mean, I think there will be a fair amount of cases that are straightforward and can be agreed between the parties, because the issues of what is the force majeure, how did it impact the obligations under the contract, and the duration are maybe not straightforward, but easy enough to agree and are fairly clear, and there won't be a huge amount of dispute. But then there are going to be a lot of the messier cases, which is what Richard and I have been wrestling with on this video conference or webinar, in sort of hypotheticals. But the specifics of each individual case in terms of what does the contract say, what does governing law provide for, what are the facts of the case, is there a direct line between cause and effect, between COVID and the relief claimed? Those kinds of messier situations are very likely to end up in more formal disputes.
Okay. Our last topic that we were going to cover was looking at material adverse effects. And again, the audience have sent in lots of questions here, talking about change of circumstances, talking about frustration of contracts. Richard, perhaps you could just embrace these issues about how easy is it to invoke what we call like the nuclear option here, where you're wanting to basically try to terminate a contract through either material adverse effect, hardship, change of circumstance, or whatever. What's your general sort of overview and advice for LNG contracting parties?
Well, I mean, general principles first. It's very difficult to terminate a contract to get out of a contractual relationship unless that contract specifically allows you to do that. So in other words, most long-term SPAs that most of us have seen or are familiar with do contain termination provisions. So they'll set out specific events which allow a party to terminate the contract. That may be due to a prolonged FM event, actually, and that's fairly common. So an event that lasts 12, 24 months maybe may allow a party to terminate. Failure to deliver or lift a certain percentage of your annual quantity commitment may give rise to a specific termination event. So you've kind of got, you've got one category of events or specific triggers that are in the contract itself. You've then got potentially, and I use the word potentially deliberately because it's extremely difficult to invoke other principles of law, such as frustration under English law, frustration of purpose under US law, impracticability under US law, illegality. I mean, these are recognized legal concepts that may, as I say, may potentially allow a party to terminate or absolve a party from performing, but the bar is extremely high in most cases, and those are very difficult legal concepts to invoke successfully. And if you take frustration, for example, the doctrine of frustration essentially, which says that if an event is sufficiently serious or grave as to effectively undermine the whole purpose of the contract itself, so in other words, something has happened which renders the whole contract impossible to perform, almost irrelevant in some respects, then it may be possible to argue that the whole point of the contract was frustrated and so on. There have been very few cases, at least cases that I'm familiar with, whereby these kind of concepts have been successfully argued in order to unwind or terminate the contractual relationship. So my advice would be, if you want to cater for termination, if you want to have the ability to review and potentially to get out of a contractual relationship, then make sure you provide for it in the contract. And that, I suppose, the last point I'd make on that is material adverse change, or MAE, which a number of us may have seen in other contexts. In M&A deals, for example, it's not uncommon to have a MAC termination right in a sale and purchase agreement, or in financings, for example. But at least in my experience, it's pretty rare to have an MAE termination trigger in a long-term SPA. I've hardly ever seen SPAs that actually allow a party to walk away to terminate for MAC. And maybe that's something that the industry is going to have to start thinking about a bit more carefully. Is MAC, material adverse change, worth considering as part of your termination regime in the contract? And if so, then you get into questions about what constitutes material adverse change and what doesn't. But leaving those aside for now, I think that's probably a safer route to go than trying to argue that one of these non-contractual rights should be invoked.
Thank you. Chris, I've had a few questions come in quick succession, which is sort of futuristic in a way. It's saying, do you think that COVID-19 will actually trigger material changes to new LNG contracts in the future? So will we start to sort of change the framework in the future for long-term SPAs?
That's a tough one.
We haven't had any easy questions, have we?
Yeah. Well, I guess, an obvious point is that, following some of the comments Richard made, it much more likely that force majeure clauses are going to get a lot more attention in the negotiation of contracts, that termination clauses and conditions will get a lot more attention in contracts. even before COVID, just talking about sort of broader commercial trends in LNG contracting and what the effects might be, even before COVID, obviously there was quite a bit of trend towards shorter term contracts. I mean, I don't want to repeat the history of the LNG industry, but just for all the reasons we all know very well over the last, say, 4 or 5 years, there have been generally fewer long-term contracts, shorter term versions of long-term contracts, meaning more 10 to 15 years than 15 to 25. Greater degrees of flexibility, sort of under the pressure of the flexibility of US LNG and more FOB kind of options in the industry. Those trends were underway already. I would be surprised if they didn't continue apace or even get accelerated by the effects of COVID. I mean, as I said earlier, flexibility has value and it has purpose even without COVID, and it's been something that's been favored by ample supply, liquidity, and commercial flexibility in the industry. I think those things are just even more at a premium now than ever, and will be more sought after in future contracts. That's my take on it.
And for sure, I think everyone is seeing COVID-19, the oil price war, the demand destruction, the lockdowns as being sort of black swan events that no one could reasonably have foreseen sort of for our business, but just demonstrates the risks that are in our business. If you are an LNG producer, if you are portfolio aggregator, if you're a buyer, whoever you are in the chain, these risks are now genuinely there, they're valid, they're happening. I'd like to just say, first of all, to the panel, thank you so much for taking all of these completely sort of ad lib questions. Nothing here is being rehearsed or practiced. From a moderating point of view, I think that it's so clear to me that we are in a sort of a new world with a fundamental sort of change of focus at the moment. And what it, I think, throws up to me is the importance of professional advice services when you want to claim something as important as force majeure, for all the reasons that you mentioned, Richard, and all the analytics and the evidence supporting those claims. So I think it shows me that these sort of services are going to be in high demand. But just to close it now in the last few minutes, would each of you like to make some type of final sort of comment to our audience? We've had literally tens of questions come in. I've tried to group them and show you the type of things our audience are thinking, because they're really, I think, concerned about just being able to perform a contract, number one, and getting through this next period, which is, we don't know how long, but we do foresee a destruction in demand. And lastly, you know, what advice you would give to anyone on the line here who is listening into this? So it's a sort of a final part of comment for both of you.
Do you want to start, Richard? Or
sure. Happy for me to. Okay, yeah, sure. You've done a great job, Pat, because I've seen the number of questions flashing up on the screen as well. So terrifically well done to moderate the discussion and to deal with some of those questions. But look, I mean, I think on an advisory level, I would say be specific in your contract. Most of the rights and obligations that we've discussed today start and end in your SPA. So pay very careful attention to what is in there and to what is not in there, rather than trying to rely on sort of other legal doctrines or what have you. So that would be my first and most important piece of advice. I think, look, I mean, SPAs have evolved. You know, you alluded to that, Chris alluded to that over time. You know, they've evolved in terms of optionality and flexibility. I think we're all familiar with that. You know, we've also maintained, or SPAs still have, for the most part, price review concepts. So, you know, the ability to review price over a period of time or at certain intervals in a contract every 3 years, 5 years, whatever it may be. But what we haven't had to really grapple with before as an industry is what's happened to us now, i.e. the sort of the simultaneous occurrence of COVID, a pandemic, and the oil price plummeting as it has done. So that's almost unique, at least in my experience in the industry. And I think SPAs will have to adapt to that. I think we are going to see new provisions or adaptive provisions around FM, around termination, around volume flex as well, because I can't see otherwise how parties can manage their positions satisfactorily over a period of 10, 12, 15 years. The risks otherwise become so extreme. The risks of being locked into a contractual relationship over that period of time that is uneconomic or unfavorable, potentially in the extreme. I just see that risk is almost too great not to look at, not to revisit some of these underlying provisions that we've all seen a number of times in negotiations. So my forecast, my prediction, I think, coming out of this is that we will start to see new concepts finding their way into some of these long-term contracts, rather than just those conventional price review, price reopener, and sort of flex type provisions. I think we're going to have to see that.
Thank you. Thank you very much, Richard. And to Chris, your parting comments and advice.
Yeah, I think focusing on the main theme, and the specific point about using force majeure, making force majeure claims related to COVID, specifically, I would agree with Richard and say certainly be specific, be careful about the specific provisions of the contract, the legal provisions of governing law, and what is sort of envisioned or intended, but also be precise. Be precise about cause and effect, be precise about what it is you're claiming and or defending, and whether or not the force majeure directly ties to the claim, or whether there's other surrounding conditions that are actually causing the issue in question. And with all of that, I think also be reasonable. I think, you asked the question, I think it was earlier, Pat, or maybe one of the audience did, about, are there settlements or are there agreements between the parties? Obviously, the easiest thing is if through thinking through the kinds of issues we've been discussing, the parties can agree and have a sort of amicable approach to force majeure and, get through this period and move on. Productively. That's usually best for the parties and best for the industry. Yeah. But sometimes that's not the case because it is complicated.
And there's so much money involved.
Indeed.
I'd like to thank both of you very much indeed. And some of the audience have also sent in their thanks for this session. We have had so many questions posed at us, but we will try to get back to those people where specifically we haven't been able to address your issue. And I would also say to the great community that are following us here with this webinar, that if there are topics that you would like us to consider to run in the future, do let us know, because clearly I think there's scope here for us to get our experts online and reaching out to you at a time when it's so difficult to do that. So please let us know if there are topics that you really want to know more about. We'll try and group those together and produce more webinars for you. It's sharply 2:30 London time, so that's 1 hour. So I think I propose to close the webinar now, saying thank you to Richard and to Chris and to the CWC team for putting this together. And we look forward to seeing you all again soon somehow. Thank you and goodbye.
Thanks, everyone. Take care.